because that bill is yet to go through the processes which question or interrogate its validity. And once that is done, maybe then somebody can come to court. But for now, it is premature to come to court. That was our argument. So the court has reserved judgment. We are waiting to hear what the court says, but that does not stop any of the law-making processes that are in play at the moment. Any questions?
What will tell right? But in the all right, so I think we have heard from the lawyer for the government that the court reserved judgment after I think all the what it means is that they will now go and consider. But as you can see, the arguments we are making, I think the court has entertained the arguments. Our clients, there were two types of clients. The first ones were the war veterans who were saying that the president failed to fulfill a constitutional obligation by chairing cabinet and facilitating cabinet processes where he would benefit from, and that is contrary to provisions of the constitution. So we will still deal with that. So among other provisions that they raised was the issue to do with the liberation struggle, one person, one vote, and that the new proposal, which would have a president elected directly by parliament, would be contrary to those ideas. So there was a lot of debate here and there. Of course, also the issue that the president himself did not depose to an affidavit. It has been placed, and the court is going to decide on whether they should consider the merits which came from the attorney general. I think that was from this. Then the other matter, which we started arguing earlier than this, was from a citizen who is a former member of parliament, who was then also taking parliament to account for it facilitating debating and asking people to comment on a bill which is clearly on the face of it contrary to the constitution, that it wants to amend term limit provisions, and then the incumbents will benefit. And the whole debate was whether or not the court must wait until parliament is completed. I think that is what most of the afternoon, morning, you could see we took a lot of time on that. The court was weighing whether or not it might not wait. But there were clear indications that the court was with us in terms of saying that the bill does contravene section 328, subsection 7. They haven't, I'm saying in the exchange to those who are watching, etc. It is well that it appears that there appears to be, well, are we not supposed to wait before? Now, what is very important, I need to say it, and it's very interesting that it must be said, is that this whole issue in social media on whether section 95 is a term limit or is not term limit was not an issue here. We made presentations that it is a term limit provision and so forth. The respondents in the first one, the parliament, they didn't question that. They didn't even make any presentation to that. And then in this current one, the court did refer to, they actually wrote about, I think the bulk of their written arguments were on that, but they didn't motivate. It appears clear and settled that both on the side of the court and others, it's clear that those are term limit provisions. So we await the judgment of the court in these issues, when we also look forward to them, I think, being faithful to what is happening. I don't know how the courts will observe it, but that is not the end of the matter. It's wearing another head, which I can easily wear here. That obviously the court process may be one of the many ways in which those who are opposed to the bill would have to take processes. One thing which would make sense is that Parliament must wait for these judgments. It's very important. It's apex court. The arguments were alive. The Parliament people were there. All the officials of Parliament were there with their lawyers. And the court said we are reserving judgment, meaning it has to think about it. Then even in the other one, again, they have to think about it. But to just proceed as if nothing has happened, it would have been different had the court made a decision. I know that some of these people thought that the reason why they actually postponed the sitting of Parliament from, I think today or whatever, they were actually looking forward to a situation where the court would just dismiss these applications. Then they will celebrate and say that our way has been cleared. So we are now going, no, that is not going to happen. It does not happen. And then there's also the hint from the court. I'm sure if you followed up, I don't know how you were able to follow. At one of the interventions during the first case, when the court was saying, are we intervening now? They seem to be thinking that there must be a referendum. They're saying, look, but I think Justice Hachkar did make reference directly a question to me that is that not an issue that must go to a referendum or something along that line. So I was very happy with what took place inside